Hey Nina, good to see you again.
It's great to see you, Dan. It's been far too long.
I know I looked and it's been about a year almost to the day since we last spoke and there's been this thing going on called a pandemic. I don't know whether you heard about it, but we seem to be at a different stage than where we were a year ago though I think we thought a year ago we were becoming in the clear too. So
That's true. That is absolutely true. We were beginning to see the light at the end of the tunnel, and it was there for a while. It was real, and then all of a sudden it receded and became very dark once again. But hopefully, this next time around, we really are genuinely headed to a new normal. Not the same one we had before, certainly, but perhaps a new normal, which would be exciting.
yeah, I think so. And judging by the um, calls I've been getting, or frankly, the lack of them the last couple weeks, I think employers are also ready to sort of turn the page on the pandemic. I think more are bringing employees back to the office. They're either dropping or not necessarily implementing vaccine mandates, even mask mandates, which were fairly routine, seem to be getting lifted a lot. So, I think at least for the next couple of months or so, um, perhaps until a new variant comes along, we seem to be in a good stretch for now.
Yeah, thank goodness. Perhaps then, Dan, we should devote our time to talking about something other than the pandemic.
I would love that. Why don't we talk about paid leave? Which, as you know, on January 1st in Connecticut, um, Connecticut's new paid leave law came into effect with big changes also to the Connecticut Family Medical Leave Act. So, what have you been seeing on your end?
Well, it's really very exciting, obviously, for employees because these laws are transformative, and we have yet to see how they'll be as they play out. But they, in writing anyway, they really are transformative in terms of the rights of the employees. And I, it's really too soon to tell. Connecticut paid family and medical leave act leave, I think, just took effect in January 2022. But certainly it's on everyone's minds. What does it entail? And we could talk a little bit about how that works. And also, the other law, the pay, I think you called it the range. The range of salaries law. I think of it as a pay equity law, and I find it also very exciting in terms of the employee. So, which one should we talk about first, Dan?
Why don't we talk about the wage range law too, to
Sure.
talk about that? So what do you think people need to know about this wage range law?
Sure. So this is a law that essentially it was effective October 1, 2022, and it allows for, I see it as, I refer to it as sort of like a transparency law. It requires employers to divulge to applicants the wage range for a particular position at their request or prior to the time that the applicant has made an offer. And then for existing employees, after they've been hired, and the law took effect after they were hired, if the employee requests it, or if they're changed from one position to another, again, it puts the onus on the employer to disclose the wage ranges for these positions. So what does that accomplish for employees? I see it as an opportunity, particularly for women, to knowledge is power, right, Dan? For women to know, gee, I'm doing comparable work to Joe over here, and yet look at this disparity in our wages. And at the same time, I think, and I'm sure you would agree, it gives an opportunity for employers to take a deep dive when they're otherwise too busy doing their day jobs to do so, and examine how they're paying their employees to ensure that they really are doing them in a fair and equitable manner across the board. What about you, Dan?
I think this is one of those laws that's good in theory and mostly good in practice. I think the issues that we're seeing is I think for smaller and mid-sized employers, they don't necessarily have the data at their fingertips. I think for larger employers, they're used to dealing with ranges. They have the systems in place to really calculate this easily. For some of the smaller employers, they may not have thought about it. And so it really does require some extra time about that. I think once employers get used to it, we've encouraged them, this should be something you put in every offer letter. Then you've sort of standardized it. According to the law, that's the time, at least the latest time an employer needs to tell employees or applicants about their wage range. So I'd encourage employers, build it into your systems so you're not caught off guard about it. And look, the wage range law doesn't prohibit employers from paying employees differently. I think, as you note, it's more of a transparency law, and there may be good reasons why you pay employees differently. Someone has been there for 5 years. Someone has higher performance than someone else, and you might even pay people differently based on where they work. You're going to pay someone in a metropolitan area of New York, New Jersey, Connecticut very differently than you're going to pay someone out in Oklahoma as well.
Absolutely. I think, one other aspect of this law that is important to note, and you touched on it here, is that it does require pay equity in situations where the work is comparable. Before the standard was equal, now it's comparable, and that means in skill, effort, and responsibility, and obviously also in geographic location. So in some respects, it really opens up for employees the opportunity to make that argument. I may not be doing exactly what John is doing, but here, if you look and have a broader perspective, I am performing essentially comparable functions to him, and then that's an evaluation that is going to need to be made. But I think it does expand the opportunities for women, particularly, to look at their jobs and assess whether or not they are comparable in terms of skill, effort, and responsibility. And then that's a dialogue also that I would encourage between employee and employer to explore whether or not they are being paid inappropriately before you head toward litigation. I mean, I think, as you will point out, most of your clients, if not all yours, Dan, really do want to do the right thing and to pay fairly.
Yeah, I think from what I've seen, no one really wants to pay people. No one want to pay people unfairly. But I do think that sometimes situations happen where people do get paid differently. For example, you're trying to recruit a candidate from outside. You may end up paying more than you would to your existing employees. And so that inequity, whatever the gender reasons that I think we all agree should not happen, but those types of differences are the ones I think employers need to be mindful of, because those are unintentional, but under what you've said as well, those inequities can lead an employer to a lawsuit as well, just because you're not paying people who may be performing comparable work the same.
Exactly.
And so every change you make should have a domino effect as well.
Right.
Why don't we also talk about the paid leave for a second? And I'll start on this one, which is, I think for employers, we're seeing again the employers who are less than 50 or more employees who have never had to deal with FMLA before, never had to deal with Connecticut FMLA before. Now they are subject not only to the paid leave provisions, but to revisions to the Connecticut Family and Medical Leave Act as well. And I think for employers, they need to understand two things. One is paid leave is really income replacement, and that's done by the state. That's a state benefit program. FMLA is job protection, and that's on the employer to keep the position open for an employee who needs to go out on a leave. And if employers start to understand that those are running on similar tracks, but they don't quite diverge all the time. I think employers are better off and can start managing it a little bit more efficiently than they might have before.
Yeah, I would agree. I mean, there are a number of different moving parts to this new law, and I'm sure it's going to take a little while to all sort out. Just even prior to the Paid Family Medical Leave Act leave, the Connecticut state law required employers with 75 or more employees to provide 16 weeks of FMLA. Now we have a situation where, if you have one employee, you may very well be required to provide them with 12 weeks, not 16, 12 weeks of FMLA leave. And who is eligible for that leave is also expanded. In addition to the usual suspects, the serious health condition or the caring for a family member who's dealing with one, caring for a child, there's now serving as an organ or bone marrow donor or being a victim of family violence. But the definition also of a family member has expanded to reflect the reality that is our state, which is sometimes a family member may very well be, a loving grandparent or a loving, a lovely family friend who is taking on this role of responsibility with respect to a child, and needs that leave just as much as a mother or father or other parent might need that leave.
Yeah, I still think there are a lot of questions that need to be answered. I keep hoping that any day we're going to see the new regulations coming out from the Connecticut Department of Labor. I've been told they have been in the works for many months, but as of the time of this recording, they still haven't been released. I think once those new regulations get released, which again could be any day now, from what we've been told, I think it'll start to answer some of those questions. What is a family member, a person who acts like a family member,
Yes.
as the statute says? So I think once we get a little bit of those answers, I think employers in particular will be able to start implementing this law a little bit more easily.
Right. And I think time will tell. I mean, I know the definition is an individual related to the employee by blood or affinity whose close association the employee shows to be the equivalent of family relationships. And there probably will be some disputes, Dan, between you and I, between employee advocates and those representing employers as to what would constitute that kind of relationship, that level of closeness that would enable that employee to be covered under this new act.
Yeah, I mean, I think laws are always best when they're clear, and I shudder to think of some of the drafting language that we're just going to have to see in the courts because of this language. What does that mean? Is that a step equivalent? Is that uh, you know, look, I've had people in my life who I've called uncle and aunt who are not my uncle and aunt biologically. So, and I think many other people have those same types of close relationships. So it'll be interesting to see as this plays out over the next months and years, some definition. I think most employees are very conscious about the leave that they take. They want to be respectful to their employer. They don't want to be seen as being abusing the system. We're always just going to have these outliers that you're either going to have the employers that aren't giving the time that they really should be giving to employees or cutting it short. And then you have employees that are going to try to game the system um, about it. Most people on both the employer and employee side just try to do the right thing, try to be fair to your employees as well. I think we won't see as much litigation perhaps as some people think.
That's helpful.
Before we wrap up, We actually got a new piece of federal legislation, which is very exciting because we haven't had any federal legislation really much, it feels like, to speak of beyond COVID related legislation in years. And yet we have a new statute signed by President Biden that speaks directly to sex harassment about it. What do you think about it?
Well, I obviously, Dan, I'm a big believer that everyone should have their day in court if that's what they choose to do, and have a public reckoning of a dispute that they're having, rather than be constrained to not have a jury of their peers decide where the truth lies, to have it, limited to arbitration, which is really a non-public forum. So the idea that we finally would have an opportunity for those who have been survivors of sexual harassment not to be constrained to have their truth put forth in a non-public forum, but actually have the opportunity, if they so choose, to bring their case in court. I think it's great. I think sometimes there are some employers who really need that fear that they will be exposed publicly, to ultimately do the right thing. And frankly, even those employers who have a dispute where they feel like they've done nothing wrong, I think it's helpful, and part of the Me Too movement, indeed, for someone who has gone through sexual harassment to have an opportunity not only for herself to be heard, but for the public to know what's going on. And I sometimes expect that what will happen, as does happen, is that others will come forward, Me Too, when they hear about that individual's experience. And that's another benefit I see to this law taking effect.
Yeah, and just to be clear to the viewers, the law prohibits employers from mandatory arbitration provisions for individuals who want to bring sex harassment or sexual assault claims against their employers. And so I think we've seen that sort of trend on openness. We've seen it on the confidentiality of sex harassment settlement agreements, and really whether those can be tax deductible, and some states have additional restrictions as well. So it's another level of what we talked about at the beginning of transparency, which is if claims should be aired out in the open, and employers can confront them publicly, and address them in the same way that they would other claims as well.
Yeah, exactly. Isn't that we have a theme here going, which is transparency, which I think is on balance a very positive development.
Yeah, it'll be interesting to see, really, just to close this thought, where the Connecticut legislature goes this year. You've got some bills on captive audience meetings. You've got bills on scheduling that are coming up, and even the debate on restrictive covenants and non-compete agreements. Those are all on the table this year with the Connecticut legislature. It'll be interesting to see. We are in a tight labor market right now. The sort of great resignation we've seen, a lot of movement in law firms and in other industries as well, of people moving. So it's an interesting time, sort of as we come out of this wave of the pandemic, to see what the next year brings. Any final thoughts, Nina?
Well, my final thought is I'm looking forward to another discussion with you, Dan, about these, new developments, and we'll see where they take us. And maybe we won't allow a year to go by before we check in with one another to discuss them.
Well, I don't know about you, but after the year that we have been having, I need some vacation time as well. So I'd encourage all of our people watching this, take your time off this year. I think we've all earned it
I did. I did.
as well. And we'll catch up again later this year and see what the legislature has brought.
I look forward to it, Dan. It's always a pleasure.
Thanks, Nina.